This video synthesizes Chapter 6 of Information Technology Policy and Strategy, authored by Professor Richard Boateng. Every physical step goes mostly unnoticed, but in the digital space, every interaction, click, and pause leaves a continuous, invisible trace of data. Managing these traces requires a specific definition of data privacy. It is an ethical and legal commitment to safeguard personally identifiable information, the data points that connect digital actions back to a specific human being. The frameworks we will examine are built on the premise that identifying data belongs to the individual, even after a platform collects and stores it. Public awareness of this shifted during the Cambridge Analytica scandal, when the personal data of millions was improperly acquired and deployed to target political advertising. To understand the resulting shift in organizational requirements, we will map the digital trail, examine the security-privacy friction, and analyze national government boundaries. Operating within modern legal and ethical frameworks requires organizations to treat data governance as a core architectural feature. Every website visit, location ping, and app launch creates a digital breadcrumb. Aggregated, these form a digital footprint, a composite of your online presence. This footprint divides into active data you intentionally share and passive data tracking your unrecognized behaviors. Consider a user named Alice. She has a conversation offline, and hours later, an advertisement matching that conversation appears on her phone screen. A common reaction is to assume the device's microphone is secretly recording audio to serve that ad, but direct eavesdropping is inefficient. By aggregating Alice's passive digital footprint, her search history, location proximity, and browsing habits, predictive algorithms can anticipate her interests and conversations. We trade anonymity for the convenience of hyper-personalization. This permanent record of our habits forces IT systems to manage massive volumes of sensitive behavioral data. Zooming out, corporate servers pull in millions of footprints simultaneously. This creates a paradox. Maximizing systemic security inherently reduces individual privacy. IT systems track user behavior to stop cyber threats, but building that defensive wall requires creating pervasive user surveillance. The second point of friction is storage. Retaining data over long periods allows organizations to analyze behavioral trends and improve services, but prolonged retention turns servers into high-value targets. If a system holds years of historical data, a single breach becomes catastrophic. The third friction point is sharing. Organizations integrate with third-party vendors to optimize logistics and operations. Every time a corporate database connects to an outside vendor, the entire system multiplies its external points of vulnerability and risk. Companies attempt to regulate these risks internally. This document from Highland Bank outlines specific internal guardrails. We can see an information security policy and a privacy statement explicitly designed to govern employee actions. But internal documents cannot self-correct the paradox. The drive to extract utility from data will consistently outweigh privacy concerns unless external intervention forces a balance. That intervention comes at the macro level through national data protection policies. These legal frameworks act as jurisdictional boundaries over corporate servers. They explicitly mandate how personal data can be collected, stored, and shared within that region. Governments implement these policies to standardize business practices, foster consumer trust, and uphold democratic rights to privacy. They also dictate international trade. A foreign business simply cannot operate in a protected jurisdiction unless its IT architecture meets stringent local standards. The European Union's GDPR provides a prime example. Establishing strict rules for handling citizens' data forced a global realignment in corporate data processing. These national policies function as necessary structural guardrails. They help prevent the digital economy from collapsing under the weight of its own vulnerabilities. To see how abstract privacy rights become operational law, we can examine Ghana's Data Protection Act of 2012, known as Act 843. Act 843 covers entities processing data within Ghana. Key provisions enforce documented user consent, technical data security, and individual rights to access, correct, or halt data processing. Fourth is mandatory registration. Data controllers must operate transparently by registering their activities with the state. To oversee these rules, the Act established the Data Protection Commission. Breaching these provisions triggers strict enforcement mechanisms, including severe financial penalties and potential imprisonment. Act 843 takes the ethical philosophy of data ownership and hard codes it into operational reality, attaching tangible consequences to institutional failure. When we view the system together, we see a balanced ecosystem. Individuals generate data, corporations aggregate it, and national laws enforce boundaries. This tension is permanent. Users demand integrated services while requiring absolute protection of personal information. If an organization treats data privacy as a secondary concern, they risk a catastrophic strategic failure. Legal frameworks like Act 843 ensure that the drive for corporate security and utility does not destroy consumer trust. Because technology continuously adapts in real time, the national policies and legal frameworks governing it must route and connect just as quickly. The evidence suggests that robust data protection provides the institutional trust necessary for a digital economy to function.